Okay, I'm going to call us to order. It is Tuesday, March the 20th, 2018, in the City Commission Chamber. This is the Independent Ethics Board, City of Tallahassee. It is a few minutes after 4 because I do not like to be on time. I will note the presence of a quorum. We are missing Ms. McNeil. She has an excused absence. I do not know if she will be able to join us late, but I'm assuming that she will not. So the first item on the agenda is the minutes from the last meeting. Does anybody have any comments or corrections to the minutes? With that, Mr. Holloman moves the minutes and Mr. Davis seconds. All in favor say aye.
Aye. Aye.
Opposed, like sign. The minutes are approved. I do not know about Mr. Grant. Have you heard from Mr. Grant?
If you'll recall, Mr. Chair, he is traveling for work, and he was kind enough to let us know last month.
That's right.
So he, at your discretion, is excused for that.
Okay. Well, since he announced it last month, he's excused too. I completely forgot about that. Thank you for reminding me. What I'm going to do, even though we have an item on the agenda that says public comment on agenda items, what I'm going to do for anybody who submits a card is I'm just going to take that card when we get to the item. So I see one card here on number 6. Don't worry, I will get to you when we get to number 6 rather than at item 4. I think it helps us keep everything in the individual boxes, and we will do that from here on out. We will keep on the agenda the public comment on non-agenda items, so there's always a chance for anybody to raise any issue that we don't have. Next item on the agenda is the Ethics Officer Report. Ms. Meadows-Keefe, you're going to be recognized. We're going to go through this one page at a time, as usual.
Thank you, Mr. Chair. I'm looking at minutes. I'm now looking at my report dated March 20th, 2018, which represents activities undertaken since the last meeting. There have been city and county commission meetings. There was also a town hall meeting that was held in connection with the Village Square that brought city and county officials together to talk about various issues of concern to the community, which I attended. There were several website updates this month that are reflected now on our website. And I did get a phone call, and one of the audience members asked about this prior to the meeting, that a gentleman called from, and he called from Naples, wanting information on starting an effort like this, I guess, in the city of Naples. Now, he was clear that it was not something that Collier County was interested in doing. It was simply the city of Naples. So I did, Mr. Wilcox, provide your contact information. So I don't know if that gentleman from Naples contacted you. I told him really that you and your organization, along with Mr. Butzine, and your group were the best people to talk to, but he's now in the middle of trying to get signatures on petitions to get something on the ballot to set up a board similar to this. So I do find it gratifying, and I think you all would agree that people are finding us and they're thinking that this is a useful tool for their community. And the guy in Naples indicated that really the problem they were perceiving wasn't so much corruption as it was overdevelopment. That Naples is a small community and it's being overdeveloped, and there's people concerned about that, and then those connections. So that was great to actually get that call and see people are looking at us and wanting to see how you all accomplish the task of getting it on the ballot, and then how it's been implemented here. And then today, just very recently, I did provide ethics education to the National Institute of Government Procurement Professionals. They have a Tallahassee branch, so I spoke to them last year, and they asked me to come back and do another hour. So those are the highlights from this last month, Mr. Chair.
Okay, any questions of Ms. Meadows-Keefe on this item? Could you, Ms. Meadows-Keefe, before we leave this item, tell us a little bit about what will happen over the next few months related to the campaign contribution refund program?
Absolutely. If you recall, last month, we'd actually received our first two forms in the mail. We did not receive any forms this month. So we do have the updated form, number one, on the website. Number two, as new candidates have entered into the race for either mayor or an open commission seat, I have reached out to those individuals, advised them about the existence of the program, given them the form and then guidance on how to do it in their campaign, and then offered myself as a resource if they had further questions. So in terms of pushing out additional publicity, that may be something the board wants to talk about in an agenda item or not. You'll recall that this board is required to oversee the program, so we provide the oversight and we administer it. It is funded by the commission. So it may be an open item for discussion if you all want to direct any marketing or advertising of the program.
Okay. Let's let everybody ponder that and go ahead and put it on the agenda for next time, whether or not that's something we ought to or should do. And Mr. Currington, I'll warn you, I might ask you at the next meeting about whether we have a responsibility to advertise the election campaign refund program, or whether our role is really purely ministerial, making sure that the refunds are being processed properly under the language in the charter.
And I will remind board members that weren't here during the last cycle that really the way that I provided awareness to the public of the program is I just went to various candidate forums around the city. So wherever they were and wherever they would welcome me and give me 5 minutes, I would stand up and I would identify myself and I would talk about the program. I would hand out forms and cards and say, hey, if you have questions, this is how to fill out the form, and you can call me for more information. So just for comparison's sake, last cycle I had done that. That was very low cost to the board, i.e. zero, because you're already paying me a salary. So any additional efforts you would need to direct me and direct any further activities you'd like me to do.
Okay, and we can have some options next month. Next item is the monthly tracking report, and we're going to go through these one item at a time. So 117.
Okay, number 117, it is related to funds and P-card usage, and last month what I told the board is that the matter was pending and that the auditor is currently doing an audit of P-card transactions, and that is a big audit. And once that audit is complete, that'll be presented to the board, at which time I would recommend closing it. But I think it was the board's pleasure last month to keep it in an open status until the audit is complete.
Okay, anybody need to change that status on that? So we would just continue to leave that on the list until we see the results of the final audit. But you said the initial audit information, the preliminary stuff, made it look like there was probably not an ethics violation.
Correct. The small division of the city about which the complaint was about, they were kind enough to take a look at some of those transactions and were satisfied that there was no burning issue with that. So.
Okay, next item is 122.
Okay, 122 is still in a pending mode. I did speak to the interim city manager late last week related to this issue, and continued fact-finding is occurring, and he indicated to me that at the conclusion of the fact-finding, there would be a report, and the report would be public, and when the report is finished, the board will be apprised of that and provided a copy. So that is my update on that issue, and so based on that, I'm recommending that this continue in a pending status until they've completed their activities.
Okay, I have 2 cards. Mr. Butzine, is this one you want to talk about?
That podium shouldn't be there, but that's okay.
Thank you, Chairman Herring, and also thank you for giving us the opportunity to speak about the ethics officer's report before rather than after, because oftentimes in our coalition, we're talking about our issues relate to the ethics officer's report, and yet you've already accepted the report by the time we've had the opportunity to discuss those matters. I'd like to discuss particularly 122. This is the one where the citizen alleges that 3 city staff accepted gifts exceeding $100 and then was referred to the interim city manager. Now, what we know is what we read in the newspapers about this issue. We know that Adam Corey has offered gifts valued at well over $100 to former city manager Rick Fernandez. We know that the City Commission has given this board jurisdiction to investigate misuse of public position, and in fact, our coalition supported that effort. We know that the board also has jurisdiction over solicitation of gifts. So my question is, why does the ethics officer refer case number 122 to the city manager? When it's the responsibility, I would argue, the responsibility of this board to act on ethics complaints. Now, I could hazard a guess as to why Ms. Julie Meadows-Keefe has done this, and it's probably because of her reluctance to investigate matters, particularly investigate matters involving city employees, and particularly matters that involve primary city employees, primary officers of the city. And I would argue that that is really the job of this board, to ensure that you do the investigations, that you don't simply hand it over to staff to do that. And when we worked on this, this proposal in the very beginning, the wording was clearly not that the ethics officer would be a conduit to make sure that these complaints go to an appropriate level of staff, but instead that this body would investigate those possible violations. And in this case, I'm not a lawyer, but in this case, it would seem to me that this investigation ought to be very easy. While Ms. Julie Meadows-Keefe may not have particular expertise in investigations, if she can't handle an investigation because of that lack of expertise, then this board should consider retaining an investigator precisely for that purpose. And that would be the position of the coalition, and we would encourage you to take on responsibility for doing these investigations rather than simply handing them off to the city manager or other high official in city government.
Okay.
Thank you.
Any questions, Mr. Butzine? Okay, thank you. And Mr. Wilcox.
Bylaws require me to do it.
Thank you, Mr. Chair and members of the board. I'm Ben Wilcox with Citizens for Ethics Reform. I first want to say to Julie, your comments about the campaign finance program. Just wanted to let you know that our coalition is meeting with all of the candidates for city commission and making them aware of the program and trying to educate them a little bit on the goals and why we have this program. Secondly, I want to echo some of what Mr. Butzine said. I too am concerned about case 122 and concerned about the independence of the investigation into this ethics complaint. We don't really know who received these tickets from the city. We know that the city manager a former city manager was caught lying about the tickets. It's not inconceivable that the interim city manager might have been in that same skybox with the former city manager. So I really I have very little confidence in the interim city manager doing this investigation. I just don't. I think the board has abdicated its independence in allowing or referring the complaint to the interim city manager. That's
Okay. Questions for Mr. Wilcox? I want to say one thing. I have great sympathy for all of these comments. We are a little caught on this when the complaint came in before our jurisdiction was expanded. So when we originally received the complaint, it wasn't technically an ethics violation under the ethics ordinance within our jurisdiction. And we spent a lot of time talking with Mr. Currington about how far back we can reach before jurisdiction exists. This one is a little tricky, and I will admit to being overly cautious on it. I would tell you that at least I, as one member of the board, would not take this approach if this complaint were to come in today under our current jurisdiction. So, just a comment. Yes, sir.
May I respond?
Please.
Well, you have precedent in the case with Mr. Fernandez that you did go ahead and investigate, and then you issued that advisory opinion that said, there was an appearance of wrongdoing, and you kind of reprimanded him. So I still think that the board, even though you might not have jurisdiction, you should do the investigation and then consider all your options for responding. And I would also add that, since this complaint was filed, there's been another item reported in the news where the aide to the mayor, Destin Daniels, I guess is his name, reportedly solicited tickets from Adam Corey for a Earth, Wind, and Fire concert. And I would argue that that might be an appropriate investigation to also consider.
Okay, thank you.
Yes, sir.
Mr. Chairman,
More to do. Yes, please.
just a point of clarification. Is the date, the critical date for our jurisdictional purposes, the date the complaint is filed or the date the conduct occurred?
Well, in this case, our jurisdiction was expanded after both of those dates.
I understand, but is there a difference? I mean, is it, for instance, there was just a discussion about the Earth, Wind, and Fire. There may not have been a complaint filed about that, but that conduct likely occurred before our jurisdiction expanded. So I'm wondering how we would address that. Maybe Mr. Currington is the one to address it.
Yeah. I think the date of the occurrence of the event that's allegedly unethical is the controlling date. I mean, it's like a criminal statute. I can't violate the jaywalking law if there's not yet a jaywalking law. It's only once the law is passed and it's prohibited. So I think it's the date the cause of action accrues, not the date of the complaint, as it would not be when somebody reports the jaywalking.
Thank you. Can I follow up? Is it, I think Mr. Wilcox raised a really valid point about whether or not the investigation that's being conducted by the city manager's office can be done in a way that's unbiased. And is it appropriate for us to follow up with the city manager's office to inquire as to whether or not they're making an independent investigation?
That has been occurring. And that's where Julie, in a recent conversation, learned that they would actually issue a written report on this. So up until, I think she's actually been pushing them a little bit. I don't know that she'd admit to that, but she's been pushing them to do something formal concerning this. One of the issues, as I understand it, is one of the individuals who may have received a gift may not have been a reporting, the gift ban only applies to reporting individuals, Form 1, Form 6 filers, and procurement employees. It does not apply to other public employees. Now, there's a city gift ordinance also that comes into play here. But one of the individuals may not at the time have been a reporting individual, and so there's a nuance there that adds a complication, because then obviously if a person was a reporting individual and they took a gift, even if it's not from a prohibited source, they're required to file a Form 9 with the State Ethics Commission. So there's 2 or 3 fingers on this in this fist. Ms. Meadows, or Mr. Davis, I'm sorry, you had your mic down.
Do we know the date of that Earth, Winds, and Fire concert as to whether it took place after our jurisdiction was expanded or before?
I can find that out. I mean, I can Google it.
Unless Mr. Wilcox knows.
Well, I don't know, but I think it probably took place before your jurisdiction was expanded. But I would just again make the point that with the case with Mr. Fernandez and the wedding discount, that took place before your jurisdiction was expanded,
March
and you did investigate.
2017.
And you did issue the advisory, letter to the city manager. And so I think I still think it's critical that the board be in charge of the investigation here.
Okay, we will, I agree with both of you. I think we can come at this a little stronger than we have been. Once we get past this weird transition period, I think that we will be addressing some of these more directly. It won't be a matter of referring something over which we don't have jurisdiction to the appropriate city person. And Julie just told me that it was March, Mr. Davis, March of 2017, so 1 year ago was the Earth, Wind, Fire concert.
Mr. Chair,
Mr. Currington.
if I could, because I think there may still be some confusion with respect to Mr. Davis's question. I don't think the day of the concert is controlling. It's the day they accepted the tickets.
Oh, okay.
I agree with that.
Never took the ticket.
Which likely was before the concert.
Or the day of the activity, even if tickets were never accepted, if they were solicited, it would be the date of solicitation of the tickets, which could be months before a concert. Ms. Meadows-Keefe.
Okay, and I just do want to point out one thing about 122 that the board may want to think about or direct my activities. The reason that this matter was referred as it was is because the board bylaws require it. So the way that matters in the past have been handled is these are employees. These are not appointed officials. These are not commissioners or aides. They are employees. So granted, they're high-level employees, but they're employees. And our bylaws say that they are reported to their highest level of management. And so, I mean, we've had line workers investigated, and that's the way they're handled. So it wasn't necessarily a choice on my part where I lack.
But Ms. Meadows-Keefe, haven't we since the time of this, haven't we amended our bylaws to say that if the complaint involves a high-level official?
We have not taken that on yet.
Okay, so that's still in draft, so that will be on our next agenda.
Great.
We've talked about expanding it to say that it's a high-level employee and kicking it to their supervisor
Might not work.
doesn't seem the most rational thing, that the board would take whatever action it deems appropriate. So we'll have an alternative, and that will be on our next agenda.
Right.
Okay, so for the moment, what we're going to do is, we're going to bring this back up at the next meeting. We will have a little bit more information, whether the city manager, the interim city manager is finished or not. We will have a little bit more information to discuss.
And maybe I'll ask him to come.
Maybe you guys will get something, one of those private information kind of things.
He doesn't enjoy my calls. I'll just tell you that.
Okay, any other questions on this item? Okay, 128.
128. This was a matter from last month, which was a complaint that came in related to the qualifications of a particular individual to perform his or her job, and that the individual was retained in the position due to a relationship with the management. Again, pursuant to the bylaws, this was referred to the assistant city manager, who conducted a follow-up discussion and evaluated the employee and past employee evaluations. It's actually a long-standing employee with good evaluations. So my recommendation is to close that matter.
Okay. Anybody have an objection to closing this? Okay, without objection, we will close it. Item 129.
129, I didn't basically close it on my own, but I kind of did do a desk closure. This person had an issue with Palm Beach County Building Department and getting permits and stuff addressed. So I told her to call the Palm Beach Ethics Commission and gave her that number. So I recommend that one get closed.
And again, without objection, that one's closed. Item 130.
Okay. This is one held over, I think maybe from last month, that this individual complained that someone was hired with misstatements on their resume pursuant to a certification that the individual possessed and said they possessed it on their resume, were subsequently hired, and the credential had expired. So I did refer that to the assistant city manager. The assistant city manager, again, went back, pulled the individual's resume, ascertained that at the time the person was hired and submitted the application, I'm not sure about the hiring, but that the certification was valid when the person applied for and received the job. That certification has since lapsed and was determined to not be a requirement for the job. I think it was an add-on, like it would be great if this person had X, Y, and Z. The person currently does not have that certification. They let it lapse. So based on that, I'm recommending that this matter get closed.
Okay. Any objections to closing? Okay, without objection, that one's closed. Item 131.
Okay, item 131 is the final one for this month. And this is a complainant who alleges that their access to city buildings is being unduly restricted, and a letter was written by management to this individual warning them about violation of security policies. Upon entering the building, you get a visitor pass for floor 2. You're not supposed to migrate up to floor 4 and then down to 3 and then wander into people's offices. So this person had been told several times about this, violated, and then a letter was written indicating that the person could still come to the city hall and to city offices, but would have to be escorted to their appointed location and then escorted out. and the person is free to attend, obviously, any public meetings that are held in any city office or here in the chamber. So I am recommending that this matter get closed.
Comments, questions? Any objection? Okay, without objection, that one is closed, and we would go on to the next item, which is our monthly budget report.
Mr. Chair, thank you for the opportunity to make this report, and I do not see that there's anything of particular interest this month unless the board has questions.
Okay, it looks like everything is in line with kind of our monthly spending. Any questions of Ms. Meadows-Keefe? Seeing none. The next item, and this is something that was published last month. You have on the desk in front of you the list of public records requests. You will remember last month we talked about on this list before we publish it on the website. This would be all the public records requests the city has received in the prior month, that we talked about finding a way to remove from it all of the personal identifying information so that we weren't publishing people's names or names and addresses in some cases. We have not been able to do that electronically yet, so we've got it just as a paper record this time. It's not on the website. We think that we will have that corrected by next month and be able to publish this electronically along with the rest of the agenda items. But because we've not been able to do what the board wanted to do or voted to do last month, which is take the personal identifiers out, we're just handing it out as a piece of paper at this point.
So that's just for information purposes.
So give us a minute
Okay.
to flip through this. Looks like procurement is a pretty common topic, which you would expect. Anybody have any questions or comments on these? I realize you haven't had time to digest all of them in detail, but let me just say this. If anybody wants to follow up on any one of these individually, if you will give Ms. Meadows-Keefe a call, and you'll have a little better notice and chance to review for the next meeting.
Mr. Chairman, just a request for future reports. It would be possible to change the formatting just a little bit so that the request and the requester are clear. This is kind of the pagination, or whatever the right word is. It's difficult.
Okay.
Okay.
Yes.
Got it.
Yes, we can make this more readable. Certainly.
I hear that.
Let's see, that would move us to item 5. This is the issue that we voted on last month to broadly advise city employees, and particularly the management leadership team, about to put them on notice, which they would be hopefully anyway, about campaign activities and segregating campaign activities from work activities, from their public employment duties, from any spending of any public dollars. So this is the email that went out along with the memo from this board. Ms. Meadows-Keefe, do you have anything to add?
Yeah, the reason it's back before you is for further potential uses. That's what the agenda item indicates, and I think I had talked to the chair about, I had at least one commissioner who received this and made a constructive suggestion that I wanted to share with the board, and that this commissioner felt that this kind of guidance document would have been useful when that person was running for office. And that commissioner suggested that this document be provided to candidates as they enter the race. Now, I've already described to you the process of providing information on the campaign contribution refund program. Once I check the supervisor's website and see new candidates, I send that. So logistically, it would not be a stretch for me to also provide this document. Obviously, I would probably revise it, right, so that it's directed to candidates. But obviously, prior to doing that, that's not something I'm willing to do without the board weighing in on that. But that did come from a commissioner. I appreciated that feedback and wanted to share that and make sure y'all knew about it.
Mr. Holloman.
Yeah, this, in the world of the state activities, if you're a political candidate or you're a political committee, the Department of State publishes these very helpful little handbooks. And I'm wondering if we don't have an opportunity to do something very similar here, where we could publish not only this information, but the ethics code itself and the ordinance, the applicable ordinance and things like that. Have a little handbook for on our website. You have a link, a PDF document you could download, and there will be your candidate handbook if you're running for a city commission.
Yeah, we could, let's put together for next meeting just a list of items that might go in a document like that.
And we already have a citizens ethics guide that actually I need to update because we have some new stuff. We already have a framework for doing that. So yeah, I could put that together, and just the subject areas. It wouldn't have to be long, and then resources that people could look at if interested.
Okay. How do board members feel about providing this to candidates? Now, obviously, what drove this was originally the grand jury report about use of city email for campaign purposes, and a desire of the members of this board to remind city employees that they needed to carefully segregate any campaign work they did for anybody, regardless whether it's a city person or not, from their professional jobs with the city. So it's really written more toward employees than it is to somebody who's an independent candidate, although they could very well have city employees on their campaign, among their campaign volunteers. Does anybody have an objection to sharing this? What I'm thinking, Julie, rather than rewrite this, is just a short cover memo to say, as you get ready to engage in your campaign, we want to share with you something we shared with the city staff to make it very clear that public employees need to be careful about not using public resources in any campaign activities or free speech or political speech in which they may engage on their own time, and then just copy this to them. Would that be acceptable to folk?
I wouldn't have a problem with it. I'd also like to have some reference to, hey, and we have a website, and here's our website, and here's other information. There's other information that might be useful for you on the website type thing.
So broader to the candidates, but broader than just this, the kind of whole shebang in terms of ethics.
Yeah.
Okay.
Yes.
I'm seeing nods around. Without objection, Ms. Meadows-Keefe, I think you are authorized to do that.
Okay.
Copy this with a cover
Memo.
that would briefly describe this and then include certainly the ethics code and whatever information about the ethics board you might want to provide. Certainly, we decided a long time ago that we would accept requests for advisory opinions, so if even a candidate might conceivably have a desire to ask us an opinion about something related to ethics in the city. All right. That moves us to item 6, which is procurement. Mr. Currington, I might ask you to vacate your chair for a couple minutes while we talk about this. This would involve you. This is on the procurement of legal services. This follows, I am told, pretty much the city procurement pattern. They provide this whenever they do a request of one sort or another for quotes or information or proposals. I hope people have had a chance to look through it. If I can, I'd like to start with a couple questions. We have in here on page 1, the contract duration is 1 year, and the contract extension is 1 year. I personally would be okay with something longer. So I fear that if we get in a position of re-procuring legal services every year, we're going to get in a situation where somebody's potentially winding down and somebody else is potentially gearing up, and we lose a lot of continuity when we're comfortable with the way things are working. But I don't know how other people feel about that contract term.
Well, Mr. Chair, yeah, but since we only meet once a month, that's only 12 meetings, and it's, it takes 3 or 4 or 5 probably to get your feet wet. I agree with you. It's probably too short a term.
I agree as well.
What would you guys think about a 2-year term and a 2-year extension?
I would support that. Yes, sir.
Yes.
Yes, seeing yeses. Okay. So Julie, let's make that change.
Okay. Noted.
I think also from what little bit I know about bidding, I think you tend to get a little bit better pricing if you give somebody a little bit of stability. Although I don't know if that's true in legal procurement or not, legal services procurement. Anybody have any other questions, comments? On page 2, and that sentence in the middle, member of the Florida Bar, no professional discipline, 5 years experience in the practice of municipal law, government law, and substantial. I think there's that comma needs to be an and or an or, maybe. 5 years experience in the practice of municipal or government law, and substantial knowledge of the Florida Ethics Code. Is that?
Okay.
I think that's maybe what it means.
Okay.
But that comma just seemed odd to me.
Okay. Municipal or government law, and substantial knowledge of Florida Ethics Code.
Right,
Got it.
independent of the 5 years experience.
Got it.
Substantial knowledge.
And I guess we'd need to change, Mr. Chair, 3.2.2 period of performance from 1 year to 2 years too.
Yeah.
Correct? Okay.
Yeah. And then on 3.13.2, it's at the bottom of the 4th page. We specify an hourly rate, and yet we are going to,
Right.
we have that the cost on the next page, the price for the proposal is 30% of the evaluation. So do we want to not specify an hourly rate if we're going to evaluate them on their pricing? That seems inconsistent to me. I'm perfectly happy to let somebody tell us what their hourly rate is. Just say they have to specify for the designated attorney and partners and a separate rate for any associates or paralegals or whatever, but not specify, because maybe somebody will do it for, $195
an hour.
or less.
Okay.
Yeah.
Okay. So what would you like for that to say?
Just that it must specify the amount.
Okay.
Any time the amount varies, the amount for the designated attorney or partners, the amount for associates, and the amount for paralegals. And
Got
then,
it.
And then if we get different amounts, that gives us something to evaluate on.
Got it.
And that also, it's titled After Hours and Emergency Service Rates. I didn't see anything on here on normal hours and normal service rates.
Okay. Service hours. Okay. That, yeah.
Unless
You may have a point.
I looked quickly and did not see
Okay.
it.
Because the budgeted amount, yeah, is $70,000.
Right.
But we also can't specify the rates and then have 30% of the evaluation go to,
Right.
Right, got
Right.
it.
And my last one that I would propose, we've got on the next page, on the scoring, we got 5% for a local vendor.
we pay travel.
Well, that's what I was concerned about. If we get somebody who's non-local, we could be paying a lot of travel. I'm wondering if we ought to bump that
Yeah.
local vendor percent up and take it out of someplace else. Now, it's only, like you said, it's only once a month, but still, if we end up paying $500 a month just for somebody to drive to our meeting from
You're right.
Jacksonville or wherever, that does not seem to me to be money well spent.
So what percentage does the board think would be appropriate to weight that?
Maybe take it to 10.
My preference would be to remove some of the cost price proposal, 30%. I'm much more concerned about getting good experience than I am about, $5 an hour difference in rates. So I would take some out of there and put it in the local,
How about if we drop cost to 20%, put 5% in local and 5% up under qualifications and experience, because that would address your,
Yeah, I would support that.
Ms. Davis? I'm seeing nods. Yes? Okay. You followed me?
I got the 20%, I got the
This goes to
5%.
10,
That goes to
And this
10%.
goes to 25.
Okay, got it.
So assuming those added to 100 before, they'll still add to 100. I didn't add them up, so I'm going to guess they add to 100. Okay, anybody else have any other comments? Now, what we will do with this is it'll get published, and then we have to have, according to the way the city works, we have to have a 3-person review team. So any board member that's on that review team, I would assume will recuse themselves from the final deliberation on selection. So we probably ought to have one board member. Julie can be a member of the review team, and then we will try to find a third person, which could
An
be.
update on that, too.
Okay, Ms. Meadows-Keefe, tell us about a third person.
So the board has a number of options before it. You can use a board member as described, but then that board member would not be able to vote on the final selection. The other alternative is you could compose this committee of myself, and I don't get a vote. And I have had the kind offer that the acting auditor may be willing to serve. I've also talked to a former board member who's willing to serve to evaluate. So it is recommended that you have, first of all, at least 3 members, and that you have an odd number. So it's up to the board whether you want to put one of yourselves on or not. I do have 2 willing volunteers to serve. So those are the options that I've been able to figure out since we last talked, Mr. Chair.
Okay. Thoughts on that? Because we have so few board members, I'm fine if we don't have a board member. That this committee would be the ones that would go through the bids, I guess they're bids, and evaluate to make sure they're complete, accurate, et cetera, and they would do the initial weighting on the percentages.
Right.
Right? And we, as a board, though, we would have the ability to re-weight, or are we stuck with those weights?
Well,
those
we would
percentages?
score them.
Right.
So the members of the committee would score that. And I think basically come up with a recommendation. And then the board would have to look at that and decide if that's what they want to go with. And based on the disparity, perhaps of scores, if there was a big disparity, there would have to be a justification for why the board wanted to go with someone else. So,
The board wouldn't rescore the percentage.
No.
But the board could say, Well, we think the percent is too low and we'd move this person up. Does that get us in trouble?
Mr. Chair?
Ms. Tallman.
I happen
Need
to
the
be
lawyer to
working
talk
on
about
a
that.
bid protest right now with the state, and I think the standard would be about the same. And basically, it's, we can't make any decisions that are arbitrary, capricious, clearly erroneous, or against competition. So the way I read that is, it's really difficult once you have a committee established that is taking a very subjective process and trying to objectify it. It's really, since we didn't participate in that process, it's difficult for us. It's kind of like, you know, the judge changing the findings of fact from the jury a little bit. So we have to be very careful about changing scoring. I think we generally would reserve the right to reject any and all bids, that type of thing, and we'll have language in there that will make the decision in the best interest of the city or the ethics board or whatever is appropriate. But still, in order to avoid at least, well, it's just difficult to like manipulate numbers. I'll just leave it at that.
Okay. Okay. Well, then, given that, how do you, what do you gentlemen feel about this I assume Julie is one of the three reviewers. I assume when you're talking about a prior board member, that's probably Sunny?
I did speak with Board Member Phillips, yes.
Okay. Ms. Tolleman, who you just replaced. And I think people would trust her. And then your third was the acting city auditor.
Mr. Hancock, who's in the back of the room trying not to be noticed.
who is a city employee, but I think has been outside the fray of any complaints, say. I'm not seeing people running to the mic, so. We can do that, or we could replace any one of those three with one of us. Or, I guess, with somebody who's not here.
That would show them to not skip meetings.
Mr. Chair?
Yes, sir.
My preference would be that nobody on this board actually sits on the committee. That'd be evaluated by people that, you know, just by others. And I also I know we reduced the cost price down to 20. I would rather put 10 more of that into qualification experience, particularly since, you know, really that's what to me, the most important thing is that we get somebody who has the right qualifications and experience. And I, again, would prefer to give more weight to that than to $5 or $10 an hour. Because the cost thing is simply it's, you know, it's $295 versus $275. And that doesn't tell me anything about the value of the service that I'd actually get.
So we've reduced cost price to 20% already.
That's what we discussed.
You want to drop it down another?
10. I would make it 10% and add that 10 back into qualifications experience.
So you take cost price to 10 and move qualifications experience up to 35.
I would, and also now that we're looking at management plans, understanding the specifications, that's, you know, I don't think that necessarily applies to what we're doing here. At least I'm not aware of any management plan or specification that's, you know, I don't know how that would be evaluated. And technical plan approach, work plan, I'm not sure how those are evaluated either. I think those are kind of common terms for if you're building a road or something.
Right.
But we're not building a road here. So you know, there may be some different categories that we want to look at. I think an executive summary, I'm not sure what that does either.
Shows they can write.
Okay, what are they summarizing?
I believe what they're doing is they're summarizing in a capsule form their qualifications, experience, and why they feel they are the best choice to be counsel to the board.
Okay, all right.
But in terms of those other ones that you mentioned, the board could consider striking those and then assigning that weight. Otherwise, I mean, I would look at work plan. The lawyer doesn't necessarily make a work plan. The board makes a work plan. I make a work plan, and the work plan is given to the attorney kind of on a month-to-month. So I'd say you could probably plan, you could maybe reassign that. Management plan, understanding the specifications, I think that goes to, as you're reading their proposal, that as you're reading it, it strikes you that they understand what the job is. So, you know, they're understanding what they have to do, and it's registering with them that they get it. But that may be one you play with. Technical plan or approach, I'm not sure, you may be right, doesn't necessarily apply to legal services. You're going to research the law and write up an opinion, you're going to present that opinion. So,
Well, the other, Mr. Chair, I'm sorry, the other thing about those management plan, technical plan, is that it implies, at least to me, that we're relying upon the board council to come up with a plan. And my understanding of the board council's role is to be a resource, not to drive the ship. So I would be in favor of changing language that makes it appear to people that might be applying for this that they're responsible for coming up with some agenda for us.
so now you
Okay.
have 30% to play with.
Well, how about then if we change executive summary to say something about the overall quality of the bid? And then qualifications and experience, we bump it to 50%. And then we take the three planning items and roll those into, you know, approach to serving the board, something like that, as 15%.
Approach to planning, so technical plan, it would say approach to serving
Wait a
the
minute,
board.
I've missed MBE, sorry.
Okay.
Let me drop qualifications experience back to 40. So we go 5 on a, not executive summary, but the overall quality, 40% on qualifications and experience, 10% on the approach to working for the board, 10% for MBE, 10% for local vendor, and what does that leave? 5, 10, 20, 30, 40, 20% for cost?
Okay.
Hopefully that's too much. I mean, I would prefer to have 10% for cost and put more into local vendor as
Yeah.
opposed to,
Okay, so go to 50% for qualifications
yeah.
and, or local vendor, let me go 45, 15.
45,
Okay,
50.
try this. 5% that executive summary replacement, 45% for qualifications and experience, 10% for all three of those plan, or no, 15% for all three of those plan things kind of rolled up into your approach to serving the board.
Got it.
10% for MBE, 15% for local vendor, and 20%, or is it 15%? That's 10, 20, 30, and 10% for cost.
What'd you say for local vendor?
10.
10?
15, I'm sorry, 15 for local vendor.
Okay.
So 5% on executive summary, 45% on qualifications experience, 10% for the three plan items,
And
10% for MBE, 15 for local vendor, and 10 for cost.
So moved.
30, 70, that's 100, that's 100%.
Yeah.
Ms. Davis,
Second.
I see you doing math.
Yeah.
Did it add up?
Did I add to 100? And you were good? Okay. So I think we just did a vote, so that was, all in favor say aye. Aye.
Aye.
And that was unanimous. So Julie, you've got, executive summary is going to be something more about the overall quality or the approach or the,
Got it.
whether or not they write in plain English. Something, the three planning things become the approach to serving the board, which is different. Qualifications experience have been what you have done. The next three are going to be what you're going to do for us, what you propose to do for us. So kind of past and future, then 10 for MBE, 15 for local vendor, and 10 for cost.
Great.
Wonderful. Okay. Now, Julie then will issue this. She'll work with the city
Yes,
folks
yes.
to issue it. We'll get the vendors. We're going to go with, does anybody have, yes, ma'am? Okay. I see. Do any of the board members have any other comments on this? Ms. Barry, you're recognized. Have your card right here.
Thank you, Chair. And boy, this is a weird position, sitting right here in front of everybody. I'm so used to going over there and talking. I just had a couple of comments. One of them was on the committee. And the first thing I want to say on the committee is I would like to see an attorney on the committee, perhaps Thomas Friedman, if you're not going to have a current board member on there, just to have someone other than the ethics officer. And as far as other people to be on that committee, you've got Citizens for Ethics Reform that is completely engaged in what's going on there. So you can pick somebody from there as well, since you didn't want to use an active member of the board. One of the things that I had a question was 3.3, the pre-qualification of bidders. And I know that you, in the job description, you described, that they were going to be doing ethics and stuff like that, but I didn't know about including ethics experience as part of a pre-qualification. I didn't know if that would bind you guys too much, make it too difficult to find an attorney with that particular expertise, but I thought that might be something that you guys would want to consider. And lastly, I want to talk about this process right here. I applaud you guys for doing that. Obviously, last time we had Citizens for Ethics Reform had issues with the way it was conducted because it was done behind closed doors. There was not a job search sent out. And we had problems with that. And we're not complaining about Jerry. He has been a great board counsel, but I like the process. I like that you guys are doing this before the next contract comes up. There were two board positions, the city ethics officer and the board counsel, that were done without doing job search. So I would like to recommend that the board, when it comes time to renew Julie's contract, that you guys go and do the same thing for that. It would do a world of good for the optics for the ethics board. It would do a lot for establishing a reputation and statute inside the community. So I would like to recommend you do that as well. Thanks.
Okay. Questions, Ms. Baer? So she just threw two things in terms of our selection committee. One is that we could replace, that she would like to see another attorney on there since we're buying legal services and we'd have two non-attorneys. I will tell you, Mr. Friedman is pretty permanently in travel mode. Well, actually, Mr. Friedman's wife is pretty permanently in travel mode, and he's in I want to stay in good stead with my wife mode. So it amounts to the same thing. Did we have any options for non-board members who are attorneys without going to the city attorney's office?
No, obviously we weren't going to do that, because we had talked about that, and the options we had talked about included a past board member, also included the city auditor, and I am a lawyer, and I will say that I do work more than anyone really, except perhaps the chair, closely with Mr. Currington or whoever that person would be, and kind of know what's expected of them. So I don't get a vote, obviously, on the final selection, but I think I'm in a good situation to evaluate whether that person is going to be able to meet the needs of this board.
Ms. Baer.
I'm sorry, I forgot to finish up one of the things about the ethics board that we really often stress is the independence of the ethics board and the independence from the city. And I believe that if you bring a city staffer into this committee, that will taint that, and I recommend that you don't do that. Sorry.
If we were to ask one of the people in the audience here, who would be our volunteer? Since Ms. Baer just volunteered you guys.
I think that's a bad idea.
I'm wondering if she raised this at your meeting last night.
Either one of them will volunteer. Any of us would volunteer.
Well, why don't you put your heads together and give us one name?
He's a lawyer.
Because if we pick, then, okay, Mr. Holloman.
Yes.
How would you feel about replacing the acting city auditor with Mr. Butzine?
I think it's a great idea.
Okay, so we would do that for the selection committee. Then we'd have the three people. We'd have Sonny Phillips, prior board member, who actually is not a lawyer but has played one on TV and does a great job, having worked with her a number of times over the years.
Better than one sometimes.
Yeah. and Ms. Meadows-Keefe and Mr. Butzine as our review committee for these items. Okay? We will do that. Ms. Meadows-Keefe is going to move forward working through the city process to get this done, and we will see results. Now, will we have an opportunity as board members to see the bids prior to seeing how you guys have ranked them? Is there any reason that we could not see them as they come in?
I don't think that that's allowed. I would have to check and see. I don't do this as a rule, but I think typically what happens is they come in, we have a noticed public meeting where the bids are opened, reviewed, ranked. I don't know if there's discussion. I will work with Mr. Libroth from procurement to make sure we do everything pursuant to city policy. But I'm not sure that that's appropriate, and I would want to make sure the board's insulated from any allegations later on that you guys had any input into the process, so that you're looking at it cleanly.
Okay, well, all I want to do is I want to make sure that the members of the board have ample opportunity to review the bids as well as your evaluation.
You'll get all of that
in a package. We have plenty of time, so we don't have somebody coming to the meeting and going, oh my God, I got 40 pages of stuff here I got to flip through. That we have plenty of time, even if we have to buy ourselves a month somewhere in the process.
And I don't think there's any issue at all with when the board makes its final selection, having all of the documents that were received and reviewed by the evaluation committee in front of them for the agenda item.
Does the current contract end this September 30?
I believe it does.
Mr. Currington,
so we
do have a drop dead date. Although I'm sure we could extend with him.
We could extend with him, but
that's just bad practice.
That's not really what we'd want to do. And we have started early enough.
Okay.
We're in
Good.
March, so we have given ourselves, I think, an ample opportunity to do that.
Okay. I'm going to go find Mr. Currington on his duty to know memo.
Yep.
You get it? Thank you.
And you could skip to 8 while you're waiting if you wanted.
Right. Actually, he should be right there. You'll remember last month we asked Mr. Currington, because the city commission in its ordinance adopted a policy that adopted in the ordinance that we would not conduct an investigation if anybody else was conducting an investigation on something similar. We asked Mr. Currington to give us some advice on what our duty was to know what the heck everybody else is investigating, particularly when many such investigations are either by practice or by law confidential. And so Mr. Currington has written this memo, and I'm going to recognize him to give us the nickel tour.
All right. Thank you, Mr. Chairman. Well, I don't know what I missed, but essentially I was asked to opine on what duty the board had to know, if any duty to know, whether there were appropriate law enforcement agencies have pending investigations regarding either a city hotline complaint or an alleged violation of the city ethics code. And if there was a duty, should its duty be limited to investigate publicly disclosed information that's in local, state, or national media of general circulation. While this board has had a duty to manage the hotline and ethics complaints, it had concurrent jurisdiction and it was free to proceed with a matter with no obligation to suspend. So it was only upon the January passing of the new ordinance that created a duty on this board to suspend an action, possibly if there was concurrent jurisdiction. So the question is particularly ripe. And the bottom line was that until this amendment, you had no duty to know or learn of another matter. They could move forward on dual tracks. But now, because of the amendment, you have a duty to know, and my opinion is that you have a duty of due diligence and to determine if there is a concurrent investigation, then to suspend your action. I think we all know, based on what we've seen in the passage of the original charter amendment and the subsequent debates in the city commission proceedings and so on, that the city does not want to use duplicative efforts. They don't want to mimic what the state Commission on Ethics is doing or what the state attorney is doing, and they don't want to go to that expense. And also they don't want to put the subjects of such complaints to the expense and burden of dual complaints and investigations. So this board has a duty of due diligence now to figure out if there's a concurrent complaint proceeding, and if so, to suspend its action. I then thought I was asked to look into the next question. So how do you implement that duty? How do you exercise your duty? And I've got a lot of endnotes that basically say the current bylaws and ordinances provide that the ethics officer can produce procedures and policies, or this board can pass bylaws. I'm recommending that the board take the more aggressive position of, I think, take the lead on this rather than delegating it to the ethics officer. But in either way, you can implement some procedures on when to learn and how to learn. So I've recommended 3 things, and I've discussed this with the ethics officer because we wanted to be pragmatic. So one way is the city communications office releases news clips, and those news clips pick up from a number of sources, but they advise us possibility of whether the state attorney is looking into something or the state ethics commission. And I think that is one way for this board to monitor, or have the ethics officer or another staffer monitor the communications office news clips. Also, I think the city commission or another agency could very well advise this board of a pending investigation. I think in cases past, the ethics officer has learned that other enforcement agencies have been asked to look into matters, and so we can gain that knowledge. And I think there are occasions when we can gain it lawfully, that it's not violating anyone's privacy and it's not violating the confidentiality or an exemption under the confidentiality provisions regarding investigations by various agencies. So I think another agency could notify you, and I think if you're so notified, then you would have a duty to suspend. And I also think either the complainant or the subject of a complaint could notify this board, would be another source. So going on to the second question, you asked whether or not you could simply rely on public sources, information that is publicly disclosed. And my advice is I think your duty goes beyond that. You may obtain information that is not publicly disclosed. So I think it's a little bit broader. And I guess I would offer one more editorial comment. It's a policy decision whether the board wants to pass bylaws or delegate to the ethics officer adopting procedures. I apologize, I lost my train of thought. The ethics officer and I discussed whether we should go to other sources beyond the city's communications office. And I would advise against that, I think, and I think with her concurrence, because there are other news clip services, very popular, some of them in the political realm. I'll use by way of example the Safety Report, Safety Review. But I don't know that this board should be endorsing one group or another of these private services. I think relying on the City Communications Office, which does a commendable job of learning what's of impact on the city, is sufficient in terms of your due diligence.
Okay.
That's it.
Any questions for Mr. Currington? The only concern I have in this is we may know that someone's conducting an investigation. For instance, a law enforcement agency could be conducting an investigation, but we don't really know what it's about. And we have a complaint in front of us, and somebody says, well, that complaint could well be covered in that investigation. In that case, would we be safe to move forward on that complaint if no one can tell us for sure if it's included? So I think we're going to hit some of those gray areas.
Well, I think in that scenario, under your situation, I think the ethics officer could inquire of that enforcement agency. Now, if they're not free to share that, to confirm or deny, and we have a number of bodies like that that will not confirm or deny that they have a pending matter, then I think you could proceed forward.
Okay,
But
so
if the ethics
it's
officer
the
has the authority-
FBI, and they won't even tell us if they're conducting an investigation, but the local newspaper says they are, and they're investigating something that's before us.
As you know, working with the FBI is a one-way street.
Yes.
Cooperating with the
A high-speed one-way street, yes. Okay, does anyone have Mr. Currington?
One other practical consideration that, again, I discussed with Julie is that, and I don't know the solution to this yet, and I don't know if you want us to pursue it, but a lot of agencies do not want to admit or deny whether there's a pending investigation. If this board suspends an investigation and someone says, well, why are you? Where is the concurrent investigation? I'm not quite sure how we're going to respond to that without outing somebody, you know. So anyway, some food for thought.
Mr. Chair?
That wasn't part of the query.
Ms. Tolman?
Yeah, I think that word concurrent tells me it's the same thing. So in other words, if the same thing is proceeding in two different venues, we defer to the other venue. But we would have to know that there is something going on in the other venue and that it's the same. And so how do we answer those two questions? Well, there has to be something now that's publicly available. I mean, a complaint or something has to be past the probable cause stage, wherever it is, such that it became public. It seems to me that we could possibly task our ethics officer with a regular survey of the applicable, you know, ethics commission, state attorney's office. I mean, it'd be one call a month possibly to see, you know, whether or not there's anything publicly available that it's only for City of Tallahassee employees or elected officials, right? And that's the scope of, you know, so it might be as simple as that.
Yeah, well, the Ethics Commission, I know, will not tell you.
Until they're past probable cause. Right.
And I can search, and I can tell you that I will know if somebody here is in front of the Ethics Commission.
Well, let's do this. If everybody's okay, let's follow Jerry's advice and bring this back at the next meeting as a proposed bylaw. And try to maybe fill in a couple of these gray areas. But let's also make it very clear that if the matter's before the board and the board in a public meeting receives or discusses or staff have gleaned that there is a concurrent investigation going on, that the board will make a decision then to delay. There's never going to be an automatic delay of anything. It'll be a board decision that we'll talk about.
So with respect to a bylaw, would we contemplating something, and I would recommend something as broad as that the board task the ethics officer with determining if there are any concurrent complaints, you know, in other venues to pursuant to that ordinance.
Well, I think Jerry was recommending some specifics so that her responsibility was bounded, which was his 1, 2, 3 bullets on page 2. I think that so I don't know. I'm probably comfortable either way, but I think he was trying to put some outer limit on what she is required to do, and obviously anything that we would learn about beyond those things, if it's concrete information, then that would be covered too. But this would be the floor, I think.
But yeah, part of the concern, member, is that just like we got a complaint from a Palm Beach citizen, I mean, we may get a complaint against, you know, somebody in Miami or something. I mean, I don't think Julie can call all 67 jurisdictions, counties, or what. I mean, where do you draw the line? And so we were trying, I guess, the idea of if we do it by bylaw or if we do it by a policy or procedure or whatever is to define the limit of the due diligence and have some you know, realistic, pragmatic
So if we do these things, we can make the legal case that we have met our due diligence. If we do more, then we've done extra due diligence. But
Right.
this am I correct that this would be setting the floor for what we must do?
Correct, correct. And I guess my point is, I mean, if we may say there's 10 hoops that the ethics officer should jump through, but not 11. And somebody says, well, why didn't you do 11? Well, they're going to say, well, why didn't you do 12? And why didn't you do 13? So, yes, I think it sets the floor, but not a ceiling.
See, my preference would be to have some bylaw that said that the ethics officer will take reasonable steps to ensure that we comply with ordinance, blah, 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 and then leave it at that. Because who knows what might come up in terms of ways for her to make sure we're complying. I would prefer not to put some kind of hard description of what it is she's supposed to do. I'd rather leave it to the discretion of the ethics officer to do what's necessary for us to comply. And frankly, I don't see a real strong duty on our part to aggressively go search stuff out. It seems to me more like this ordinance is saying that if we become aware of a concurrent complaint, then we stop. Not, we have to go out there and search everywhere for it. I don't see it that way. That's my opinion. But anyway, so
Ms. Meadows-Keefe.
I would also say that from prior experience working at agencies, if there was a complaint that an agency got and law enforcement was also looking at it, they would let you know. So it wasn't always that you were calling law enforcement or DEA going, hey, are you looking at this physician for this prescribing? If they get wind that DOH investigators, for example, are prowling around, they're going to contact your agency and say, hey, you need to back off. So there is that possibility as well, that if there's a complaint going on and other agencies looking at it, they may take steps to let us know what they're doing. So, I mean, you could hope there'd be that kind of communication.
Okay. Well, since this is not something we're voting on tonight, let me do this. I'm going to ask Ms. Meadows-Keefe to do two bylaws for us. One, the generic version of the ethics officer will advise us of anything that she becomes aware of in the normal course of business kind of thing. And the other, some more specifics. The ethics officer will, at a minimum, do X, Y, and Z, and then we'll see what they both look like in formal policy, and we'll have them at our next meeting when hopefully we have all 6 of us here, and we'll pick one or modify them or combine them or do whatever. But we'll have both approaches clearly in front of us. That meets with everybody's concerns. With that, we're going to end on ethics education, which will take us a while. So since not everyone may want to stay for that treat, do we have any other public comment on non-agenda items? If not, we're going to take about a 15-minute break, and then we will come back and we will do our ethics education for us. back? We're ready?
Oh, well, then I should go down to the,
Okay, we are back on. It is whatever time it is. We are going to do our ethics education little focus for this year. And Ms. Meadows-Keefe is going to start when she gets to the new podium. If she has her documents. What do you need? Notebook?
see a clipped together group of papers in there. Yeah.
Just give me the notebook.
Yes, thank you. Okay, so good evening, board members. As you know, each board meeting, we have what the chair started during his first term, ethics moments, where we take time out each month to do some board education on some ethics-related topic. Sometimes they're weighty topics. Sometimes they're ones that are a little more lighthearted and fun. We do take time each year, it's usually at the March meeting, to do a bit more concentrated ethics education for board members. So why do we do that? One reason is that there was an OPAGA study done back, I think it was in the early 2000s, of the local ethics organizations in South Florida and whether those organizations were effective and good uses of tax dollars to cut down on public corruption. And one of the findings in that OPAGA study that we've extrapolated year after year is that a shortcoming was that the board members were inadequately educated. So they were appointed to the commission, and some of them, although they might be lawyers or they might have been involved in government, lacked requisite knowledge to effectively do their jobs. So one thing that was recommended is that each year or periodically the boards receive education. So early in the board's history, we had a lot of education. We had it monthly, and we had it from external sources. People like the Ethics Commission staff came, and also we had the Florida Ethics Commission executive director. We learned about other agencies and how they did things. So we continue that to this day, trying to at least take a little time from business to remind each other about different requirements. And so this year we're doing it a bit differently. I'm going to talk about a few topics. I'm going to jump around a little bit, things that are of interest and relevance to you all right now at where we are. And then our illustrious board chair is going to talk about his favorite topic, which I think is Form 1. And he will make that new and interesting for you. And then finally, we're going to have our vice chair, Mr. Brian Smith, who served for, I want to say it was 15 years?
Like 10.
10. Okay, it felt like 15.
Right.
10 years on the DeKalb County Ethics Board and served as chair. Okay, and he's going to talk about the top 5 things approximately that he learned being on that board. So for me, what I'm going to cover hopefully will be pretty fast because you hear from me each month, but these are the topics that I am going to cover. A lot of them are not black letter law type topics because I think we do talk through those quite a lot. I do a lot of reading, I do a lot of presentations out in the community, I do write things, so I have lots of different information that I get. So these are the topics that I plan to talk about today, and you can see them here on the slide.
Julie, we don't have video.
You don't have video?
Yeah, I don't know what it takes to get it.
It was up earlier.
Oh, you know what I need to do? Stop for a second. Thank you for that. And you
There you
do.
go. Thank you.
Thank you for pointing that out.
Simple as turning it on.
Okay, and that is not part of my skill set. So these are the topics we're going to be looking at today. You can see them here. There are various principles. We're going to look at some interesting things the Constitution Revision Commission is doing. We're going to look specifically at one thing, which is requirement to vote if you're sitting on a body like this or on a commission. We're going to look at corrupt intent, and then we're going to do one quick case study update, and I am going to move quickly. But if you have questions or want to stop me at any time, please do that. I know you will. And you also know that at every opportunity, I always talk about what the board mission is. I talked about it this morning with contract professionals from around the city, state, county, and municipal to promote the actual and perceived integrity of our city government and to prevent ethical violations before they occur. And so we do that in our promotion of those principles by implementing them and doing them ourselves, by having accountability measures for the city. And so hopefully in actuality, in lived out practice, the city does better. And then also boards like this are important for citizen trust. So enhancing citizen trust in government is an overarching theme. And the prevention piece hinges on awareness of the board and its activities. Prevention occurs through citizens knowing what city ordinances and policies and procedures are in place in terms of ethics, and it includes the active education of employees from elected officials all the way down in a comprehensive way. So I referenced and provided to you all as a resource an article called 7 Additional Principles of Highly Effective Inspectors General by Glenn Fine. And Glenn Fine is with the federal government and served as the Inspector General of the United States Department of Justice and is performing the duties of the Acting Inspector General of the United States Department of Defense since 2016. So he, I guess, has made a practice each year of coming up with 7 principles of highly effective IGs. So he did it in 2016, and I think I shared those with you last year. And back by popular demand, he did 7 more. He's promised in a footnote that he's done parroting Stephen Covey, and he won't be doing any more after this. But the ones that he came up with for last year are here on this slide, that you should remain independent. And I think we can extrapolate these, and I have extrapolated them, and to some extent I may have rewritten them to fit, because we know we aren't inspector generals. We know that there's other jurisdictions that have inspectors general, but we do overlap some with inspectors general, and we've worked with the auditor sometimes on fraud, waste, and abuse. So the principles that I think apply to this board are the independence piece, and we hear about that all the time, especially from the folks that come regularly, that boards are tough but fair. We tell the good with the bad. I think it's very tempting to get caught up in bad narratives and to constantly be focused on things that perhaps are going wrong. But it's also important to talk about things that the board achieves. And Mr. Davis urged us, which we finally got around to doing, writing an item for the newspaper that talked about the accomplishments of the board. So you want to tell both sides of the story. You also want to provide potential solutions. Again, I think the board has done that. that as problems have come to light within the city of Tallahassee, the board has, through correspondence with the city commission, policy recommendations, etc., provided potential solutions. And we know that the city's been very amenable to many of the policy recommendations, that they have implemented things that we've recommended. The commission has come along as well with many of our recommendations, and we continue to make those. So it's not enough to identify a problem. It's also important to come up with potential solutions. We want to strive for timeliness. We don't want matters to drag out. I heard frustration today about one particular matter. There is a need to want to process things on a timely basis and for things not to sit for too long. So we strive for that. Not cutting corners. So although we're operating with limited staff and resources, we do the most thorough and complete job that we can every day. And finally, not expecting to be popular. I don't have a problem with that because I know I'm not that popular. And I don't think anyone is here because they want to be popular. You probably need to do something else. Other principles that he has come up with for this year are as follows. To promote transparency. And if you've been here for any period of time, you know that from inception, transparency has been a topic that we've talked about a lot, that sunshine is the best disinfectant, and urging the city to be transparent in its business practices and in other things that it does. The board strives for that transparency in the broadcast of our meetings and having them regularly each month. I will point out that many boards and even commission has been known to cancel meetings and not meet as often as perhaps they are scheduled to or it's recommended. I do not believe this board has canceled a meeting ever since inception. So we do provide that transparency by being here each month, even if the agenda isn't long, and we receive public comments, and we are here for people to see us working, and that's important. The next thing is to follow up on recommendations, and the board has taken, I think, great pains to make sure that we track our recommendations. And just like in my ethics officer report each month and in the cases that get reported, that they're tracked until there's some kind of final result. Likewise, with our policy recommendations, I always provide the board in my report with the actual city policy once it's signed off on and implemented. And we can see that, wow, 6 months ago we recommended this policy and here it is, it's been implemented. So you want to make sure you're not spinning wheels each month, but that your recommendations are being acted upon. Communication regularly and widely. So that's not just me or the city communicating with you all about issues, but it is communicating to the public. So that's the public face of the board. That's when I'm asked to go to Kiwanis or I'm asked to go to Rotary and talk a little bit about the Independent Ethics Board. I'm happy to do that. I love doing that. I actually enjoy getting up and sharing the work of this board. So it's communicating to the public, it's communicating with the stakeholders, it's engaging with them. So communication builds effectiveness and enhances public trust. Our written products should be clear and understandable. And as we were, for example, writing the Citizens Ethics Handbook, I worked really hard with Board Member Phillips on that, making sure that it was readable, clear, and understandable to all members of the public. The next principle is to be thorough, accurate, and timely. And I actually think that captures some of the previous principles that I've identified. But we want to take all of those and do them thoroughly, accurately, and in a timely manner to the extent we can. Now, there can be frustration. For example, when federal agencies are involved in investigating things, they aren't moving as quickly perhaps as some would like. So time isn't always something that can be controlled, but to the extent we can, we try to be timely. Taking complaints seriously. So I always talk to people about our ethics and fraud hotline, which is 891-8813, 891-8813, that if they call it, that call will be reflected on the next month's log. They may not see their name, they may not see the specific department, but they'll be able to identify it, and they will know that their complaint was acted upon, even if not much could be done, because it's kind of far away from what we're supposed to be doing. They will know that the complaint was received, acted upon, and to the extent possible, there was a solution proposed in trying to help the person. And finally, to collaborate. So collaborating not only with each other in our monthly board meetings, but to collaborate with the public, to collaborate with stakeholders, and yes, when appropriate, to collaborate with the city and have that good communication so that when we're making recommendations, that they're amenable to those. So it's cultivating that spirit of collaboration, which we saw today with Mr. Butzine going to serve on the evaluation committee for the RFP. So engaging with those people and collaborating with them help to make us effective. So if there's no questions on that or comments, I see none, I'm going to reflect that the board chair directed that I send to you last month, after our last meeting, the public corruption study that was done in 2010 in South Florida. And the reason that he sent it is it had a really good discussion of the change in the bribery statute from corrupt intent to knowingly and intentionally, and that proof standard. But, and I think we've beaten that one kind of to death, because right now, today, we have what we have. But as I was reading through this document, I did find some additional principles that I thought were applicable, and I wanted to show the chair that I did read the document. And assuming that you all maybe didn't have a chance to read the whole thing, these are some high points. That this report identified a thing called Florida's corruption tax. And that makes everybody real uncomfortable, I think, when you hear that referred to. And really what that translates into is theft, mismanagement, misappropriation, contracts misawarded that result in taxpayers paying more for something than they should. So the aspirational goal is that there be no corruption tax in Florida. So the job of not always the ethics boards, but definitely inspectors general and auditors and criminal investigators are to get at the root of those financial problems to save that money and making sure that taxpayers are getting a good deal. The other thing I extracted from this study is, again, that theme of balancing acts. And by balancing acts, what I'm talking about is that struggle between a citizen's right to an honest government and the right of public officials to serve without fear of prosecution or fear that they're going to be attacked because of their business or personal relationships in the community, right? So if you're an engaged citizen and you run for office and you have a lot of relationships, there's a potential you could be attacked for being so plugged into the community that you're in the pocket of X, Y, or Z. So public corruption laws in general strive to fix that balance, that we want the best people to come and serve, we want them incentivized to serve, but we also want to protect the public. And really what this grand jury report said is they want to avoid unintentional, hyper-technical violations. So you don't want to get so granular that you're keeping good people out of public service, which is no good. How this study came about, it was convened by Governor Christ in petition to the Florida Supreme Court. So that part I did not know until I read through it, that he identified some issues and impaneled this grand jury to take this very comprehensive look and make recommendations. There had been a prior grand jury impaneled in 1999 and 2000, and the legislature did not adopt any of their recommendations. So that's another theme that I think we see over and over again, that recommendations get made by Florida ethics commissions, by grand juries, by local ethics boards, and the people whose job it is to vote on those laws are slow to do it. So it can take many years of steady drumming for the lawmakers to actually respond. So, and then it was that whole discussion of corruptly or with corrupt intent be changed to knowingly and intentionally, and that did change 2 years ago, and that was, what, 3 or 4 years after this report. So it was not an immediate change. So bodies are slow to ask, but what does that teach? That teaches that you have to keep asking. The solution is that you not just kind of say, no, well, they're not going to do that, and you give up and fold up and go home. You keep asking. And I think this board's done a good job of every year persistently making recommendations. So recognizing that the elected bodies can sometimes be slow to act, I'm going to shift into looking at the Constitutional Revision Commission. And I was intrigued by something I read last night and decided to stick this in here. As you know, the Constitutional Revision Commission only meets every 20 years. So they have decided this year that they are going to look at comprehensive ethics reform and put that in front of voters. And what they have said is that they can't trust the legislature to implement some of these recommendations. And one of the proponents hearkened back to Governor Askew, who said that these things actually belong in front of the voters and they belong in the state constitution. So some examples are a 6-year lobbying ban for former state lawmakers, agency heads, and local government officials. So that's adding 4 years on to the current 2-year wait. Judges are banned from lobbying the legislature, state agencies, and the judiciary for 6 years. They are, thankfully, I guess, still allowed to practice law before tribunals, which is good. And then there's going to supposedly be a ban of governmental bodies from hiring lobbyists to influence annual appropriations. And that's one I need to read a little more closely, because I'm not sure if that's meaning that localities can't hire lobbyists to lobby for that. I don't know if any one of y'all knows the answer to that. I see the chair nodding. Do you have an answer? Can I ask you?
Yeah, it means cities, counties, water management districts cannot go out and hire for-hire lobbyists. They can have elected officials come up. They can have government employees come up to Tallahassee, but they can't hire the typical, we take whoever walks in the door lobbying firm, represent them to get money, whether it is for them their specific local government or for that type of local government broadly for all water management districts or all mosquito control districts.
Right. Because that's been an active topic of discussion here in this chamber about whether that's an appropriate use of funds, especially given the location of City Hall and the Capitol. So that's in there. And so if approved, and this seems like it's going to be approved, it seems like it's moving, it would appear on the November 2018 ballot. I guess it was subject to a vote of the whole commission this week, and by a vote of 28 to 5, it was approved. And if the voters approve it, it would go into effect January 1st, 2020. There's some other principles here that the Revision Commission actually drafted some constitutional language to be placed. And I think it's important language, and we're always thinking about our recommendations, right? For next year or following years. If for some reason this doesn't make it, this could be something this board could discuss. But the language states that the Code of Ethics shall at a minimum prohibit public officers or employees from abusing their public position to obtain a disproportionate benefit for themselves, spouse, children, or business entity they own or do business with. So that's some pretty direct language about that topic to be possibly placed in the Constitution. And then it tasks the Florida Ethics Commission to define what a disproportionate benefit would be and to prescribe the requisite intent, if any, required for a finding of a violation of this, and shall prescribe appropriate financial penalties. So again, the proponents of this measure, and there have been several, believe that constitutional changes are the only way to establish the comprehensive ethics reform that many seem to want. So that's an interesting process to watch. Any questions on that? And thank you, Mr. Chair, for answering my question. This next item I have, it may seem unusual, but this is an issue that we see here in the commission, and we see in local governments, that sometimes commissioners come in and out for various votes, or may declare that they believe they have a conflict. And I don't know if it was the chair and I or Mr. Currington and I that talked about whether there's a penalty attached to not voting when you really should. So if I say I have a conflict, but I really don't, I just feel like people are going to think I have a conflict and I leave. I think the discussion was, is there a penalty for that if I just get up and leave? And I was surprised to find that there really is not a penalty attached to that. So while in 286.012 it requires officers to vote except when there is or appears to be a possible conflict of interest, and then there's a form that has to be filled out and kept on file. I did review many AG opinions that says that there is no accompanying penalty right now for that, which I found interesting. So I don't know if that's something later on the board would want to talk about, but it's also a reminder to all of you that this requirement applies to you, that when a vote is taken, it's incumbent upon you to actually vote unless you have an appropriate conflict of interest. And I think the best person to ask about that would be our board counsel if you're ever in doubt. But I've seen that happen here in the chamber, and so I took great pains to look that up and see, and just wanted to remind you all about that. And there was actually a question asked of the Attorney General if you get up and leave, is your vote considered a yes? Someone asked that, and of course the answer to that is no. It's just that you weren't present for the vote. So I did feel that was important and want to remind you all of the duty to vote. We have talked a lot about corrupt intent, and that is currently the language that we have in the ethics code provisions adopted by the commission. So I just wanted to remind board members of what this means in terms of the Florida Ethics Code. Corruptly was not defined in the ethics ordinance that the city passed. But this is what they've got here in the Florida Ethics Code, done with a wrongful intent and for the purpose of obtaining or compensating or receiving compensation for any benefit resulting from some act or omission of a public servant which is inconsistent with the proper performance of his or her public duties. Well, so what does that mean and what does that look like? Because that's a lot of words. So I do have some language. This particular language came, it's from a final order from an administrative law judge, and I haven't been able to find any more, to me, apt definition about corrupt intent, because I had a misunderstanding about it before. That corrupt intent to me conjured up a plan that you've sat and planned and you intended to do a thing, and here the interpretation is that the corrupt intent can be formed instantaneously and you don't have to have premeditation. A reflexive reaction is enough. So how this was applied in this case was someone that was pulled over for speeding in a locality and said, unless you tear up this ticket, I'm going to make sure that law enforcement does not get what they're requesting in the budget. And they found in this case that that was the requisite corrupt intent, that you formulated that in that heat of the moment in getting a speeding ticket, and you were going to use your job as the appropriator of funds to try to get out of that speeding ticket. So I felt like that may clear up some confusion. Some people think this is an insurmountable mountain to climb in proving a case. Here, it was not in this. Finally, I have a case law update. And I told y'all I was going to jump around because I wanted to try to keep it interesting and non-repetitive. But this slide may look familiar to you if you've been here the whole time. I talked about this mayor, Steve Bateman, I think in the very first ethics education I provided to you all. And he was convicted of several charges related to selling his influence and actually lobbying for a client while he was serving as mayor of Homestead. And he was found guilty back in 2014, 15, and he has been out. He was sentenced to 22 months, and he's been out this whole time on bond and had appealed this all the way up to the Florida Supreme Court. They determined that they were not going to look at it. So he may ultimately end up going to jail very soon. But I say all that to say one of the principles from the beginning of the presentation is timeliness, so that there's a public interest in seeing things done quickly. Here was a gentleman that was convicted back several years ago, and now it's taken till 2018. It's taken 3 years to get to this point for him. So that's how that one in particular turned out. So does the board have any additional questions, any additional topics they'd like to see covered in the future? If not, I'm going to yield to either the chair or Mr. Smith.
Mr. Smith, you want to go next?
All right. You want me to go down there, or are we good right here?
Wherever you're comfortable.
All right. Yes, guess I'll hold my seat here. I can't follow you down that way. All right. I want to talk to you all, I guess, a little bit about my time in DeKalb County, Metro Atlanta. I served, as Julie stated, I served on the ethics board there for, I guess, almost a decade. I was, I guess, a political appointee. They do it a little different than they do here. And that was a very interesting time. And I learned a lot in that time period. My last 2 years there, I actually served as the chair, but the prior times I sat, I guess, at the foot of some very bright individuals. So it was a nice time. So I don't have a slideshow for you today, so I'll get going. The first thing I learned was to be effective, you must have government support. We had a very strong code of ethics, had a lot of bite, but we could still be stymied. The county commissioners, from time to time, would not appoint new members, so we couldn't have a quorum. We actually went through an entire year and a half without a quorum. And we were meeting 4 times a year. We were meeting quarterly, unless we had a special investigation or a special hearing to have. They also reduced our funding at one point, and I believe we had, I think we had a budget of $18,000, and the county was 755,000 people in the county. So that was very interesting. So if you don't have that support, no matter how strong your code is, you can still be stymied. Second thing I learned, in addition to that, you must have a code with teeth. I kind of look at what we have here. We have the support, financial support. I think we have a good mechanism for having members appointed. It's pretty swift, unlike what I experienced in DeKalb. But compared to the two, our code here lacks the bite. In DeKalb, we could fine employees, or we could reprimand, suspend. We could even fire certain people. So only ones we could not fire was like the chief of police, the DA. Of course, we couldn't do judges. Now, their clerks were under our jurisdiction. So we had a lot of we had a wide jurisdiction, but that code was a lot older. I mean, by the time I got there, it was about 30 years old. So it was very interesting. We had some very interesting cases. A lot of media play there because we were dealing with a lot of money, a lot of significant issues that came about. Had a lot of legal arguments, especially about we had a lot of challenges from some attorneys, where we quasi-judicial or whatever. So that was a big challenge with us as well. And next thing, we have, it seems as if external parties seem to know more about our function than that of the internal parties. That included frontline workers all the way up to senior leadership. The public knew about us. They would send in complaints, but the employees of the county, they knew little about us. We didn't have an ethics officer who was full-time. And we also, we provided advisory opinions, but we didn't get the opportunity to go into the county much to actually talk to individuals about that or about our function. So I think we could have alleviated a lot of the issues that came about if individuals would have known to seek out an advisory opinion prior to taking an action. So, but that was a good part to have. We did have a lot of county commissioners that would use the advisory opinion, and I thought that was a good thing. I learned a lot about that process. The fourth thing would be, I learned that the ethics board and the HR department should have worked more together. I think they could have invited us in to do more presentations, to work in lock in step with them, and I think that would have been more beneficial to the county. And the last thing I learned, we had to make a decision whether or not it was our duty to make the cases for the complainants, or were we there simply to hear matters and let the complainants make their own cases. That was a conflict we had to deal with a lot. But It was an interesting time. Those were some of my top 5 takeaways. I learned about personal security. That was another thing, because you would get approached about from different people. I've been at my son's youth sports outings, and I had vendors come up to me upset about some of the opinions about, the conflicts that would come up. Sometimes people would travel by your home. It was a very political town, so, that's some of the things that came with it. Most of our big cases were televised on all the local news organs. So it was an interesting time. I enjoyed it. I would like to see the point, I would like to see the day when we have the same amount of, the same type of jurisdiction and that same bite in our code. So that's all I have. Any questions?
What was your makeup in terms of attorneys and non-attorneys on the board?
Okay, when I first got on the board, everyone was an attorney. We had one former federal judge, retired. We had individuals, we had one woman, Killingsworth, Attorney Killingsworth. She was a former judge, and she had a huge ADR practice. We had one civil litigator, and we had a civil rights attorney on the board. I was the newbie. I was kind of fresh out of law school when I got on there, and I at the time I was working in the prosecuting office, and so everyone had a legal background at the time. My last 3 years, there were 2 attorneys, and everyone else was a non-attorney. We did have some former retired corporate CEOs or who served on the board, and they brought a good perspective, but the deliberation definitely changed. And we would even deliberate openly. We would, people from the gallery couldn't speak, but we would have our deliberations in front of everyone. But yeah, you could definitely see the change in the board. Now, when I look back, I see they've gone back to more attorneys on the board. And after they had a lot of fallout, because we decided to go to the press as well about the quorum or lack of and the resources. So we did have an attorney, and they were paying the attorney $1,000 a month. And like I said, we only had $18,000 budget, so that was gone with him. But yeah, the board definitely changed when we lost the legal expertise.
Interesting. Any other questions from Mr. Smith? Mr. Davis.
Who did the investigations for that board?
Well, we would hire someone occasionally, but most times we would take the information that was there. Based on our resources, we had to take that, I said we had to make a decision which route we want to take. Were we just going to listen to someone and let them make the case, or would we go out and investigate? So as the resources dwindled, it became more and more they had to make the case. We really sat up like a judge. Now, some of the advisory opinions we would research ourselves. Our attorney would research that, and he would bring back drafts, and we would read over it if we agreed, or try to make changes. Besides that, it was like a hearing. We'll let the individuals make their case. So a lot of the cases we couldn't, we would have to dismiss because, you didn't present adequately.
Other questions? Okay, I'm going to do my part here quick. You've got I don't know what, a 6-7 page handout in front of you on Form 1s, and this is a little different from the instructions that come on Form 1. I would always encourage anybody who has to do financial disclosure to carefully read the instructions because they're pretty good. The Ethics Commission, the Florida Commission on Ethics also has on its website a document for financial disclosure filers that goes through, that highlights all of the opinions that they have given on specific points that have to be disclosed on the form. Just a couple highlights to hit on page 1. You're responsible for filing the first one when you come into a job, whether it's appointed or hired. After that, you will get a reminder. For us locally, it'd be from the Supervisor of Elections. You'll get a reminder every year. So the first one, you're on your own. After that, you're going to get the annual reminder. When you leave that position and you're no longer a financial disclosure, you're no longer required to file a financial disclosure, you file a Form 1F, it's final one, and that takes you off the supervisor's list. So you put yourself on, you put yourself off, but all the intervening years, they'll send you that reminder, usually by certified mail, and you'll end up having to go to the post office to pick it up because they won't leave it at your house. The disclosure period for most people is the calendar year, and there's a box you check. There's also a box you check where you talk about which which threshold methodology you're going to use. It is important to check those two boxes. The Commission has sanctioned filers in the past for not checking one of those two boxes. So there can be a fine associated, even though you fill the form out accurately, correctly, and completely. If you don't check the box, you can get dinged. On any section on the report, if you have nothing to report, you should write none or NA in that section. Don't leave it blank. Obviously, you have to file originals. Not obviously. You must file originals. You cannot file facsimiles. And while the form is due on July 1, the penalty phase does not start until September 3rd, so there's a little bit of a grace period there, but after that it's $25 each day you're late, up to a maximum penalty of $1,500, and that is per year. So you can get, several people have been dinged for being late several years in a row and had pretty big financial penalties associated with that, with their late filings. I give an example here. For a public employee, a spouse, they have interest, they have investments, and you as the public employee have a partial ownership in your son's business. And I'll go through all of this, and the purpose for this is to help people decide whether there's two ways you can report. One is a dollar value threshold, the dollar value of each one of your assets, and the other is a comparative threshold, whether your asset, a particular asset, exceeds a % of your gross income or a % of your total wealth. The general rule of thumb, most people want to report as little as possible. You want to disclose as little of your finances in a public document as you're required to do. So usually for people who are entering their career and maybe don't have a lot of assets built up, they're going to want to use the dollar value threshold. For people who are later in their career and have some assets, have some savings, they're going to want to use the comparative % threshold. And in the example I gave here, you can see for your primary source of income under the dollar value threshold, you would have to report 3 items from the 6 up at the top, items 2, 5B, and 6, because they all exceed $2,500. Under the comparative threshold, you would only have to report items 2 and 6. So you would be reporting less, just depending on which threshold you pick. On page 3, excuse me, secondary sources of income. This is true for a lot of people who have kids and they help them get started in businesses, or people who have friends where they get involved in a friend's business, maybe just on the financial side. If you report on a dollar value threshold, if you own more than 5% of the business and receive more than $5,000 income from the business, you must report it. On a comparative % threshold, you have to own more than 5% of the business, receive more than $1,500, and receive more than 10% of your income from the business. So again, people with larger incomes and larger assets are going to be better off to pick the comparative % threshold, because in the example I gave here, where you're a part owner of your son's business, you would have to report that under the dollar value threshold, but not under the comparative % threshold, because he's just not making that much money yet. If he's not making the money, you as part owner of his business are not making that much money. On page 4, the short version of this is for real property, you do not report your home under either of the thresholds. You do not report vacation homes. So if you own a beach cottage, you and your spouse own a beach cottage with 3 other couples, you don't have to report that unless you rent it out. If you rent it out, now it's a business, and then you've got to look at the income that comes for that and see if it meets the thresholds for reporting. You own a lot or some property in North Carolina where you hope to retire one day, you do not report that because it's not in Florida. It's only real property in Florida that you have to report. and you own, along with your spouse, a lot in Florida where you hope to build a home, or maybe hope to build a home for one of your children, that you do have to report under either of the threshold methodologies, because it is neither homestead, it's neither your home nor a vacation home, and it is in Florida. On page 5, intangible personal property, I gave an example at the top, 5 different pieces of intangible personal property. Note one thing that has caught a number of people is prepaid college plans are yours. You have, even though they're in your child's name, you have the ability to go cash those out and take the cash out of them. The same is true for a lot of accounts. There are specific opinions from the Florida Commission on Ethics where people have set up accounts that they're holding in trust for their children, but if you have the ability to close that account, it is your asset and you must report it. Under the dollar value threshold, you have to report anything over $10,000, so you would have to report 3 of those 5 items up on top, the 3 that exceed $10,000. Under the comparative percent threshold, you'll probably be able to write none on your form, and that is if your total assets exceed $220,000, then no one of those items at the top, those 5 items at the top of the page would exceed 10% of your total assets. So it's only intangible personal property, where that one item of intangible personal property, in this case would be the IRA, would be the highest valued one, would exceed 10% of your total assets. And of course, there's a lot in Ethics Commission opinions too on joint ownership and ownership with right of survivorship and such. There's even one opinion where there were 2 elected officials that were a married couple, and they owned some property tenant by the entireties. They both had to report 100% of the value because they both owned 100% of the property. So you have to be careful with items of joint ownership. There are sometimes you can take your percentage ownership, and other times you own 100% even though the other person also owns 100%. On liabilities, on page 6, credit card debt is excluded. If you pick the dollar value threshold, you would have to report the name and address of the creditor for a mortgage if you have one. And if you, in this case, the example I gave, you've helped your son buy some equipment for his business, and you would have to, because in this case it's more than $10,000, you would have to report the name and address of the creditor for that loan as long as it exceeds the $10,000 threshold. As he pays it down and gets that under $10,000, you would no longer have to report it. And but if you drop to the comparative percent threshold, once again, you're going to be able to write none on your form, unless the value of your mortgage exceeds your net worth, which is not going to be true for most people later in their careers. That would be the only time that you would have to report that mortgage, is if it exceeds your net value. And then on page 7, interest in specified businesses. This is a unique list that applies to very few people, but if you own an interest in any of these businesses, or if you were an officer, director, partner, proprietor, or agent for any of these businesses, you will have to report your interest in the business. Most people are able to, that I've worked with over the years, most public employees are going to be able to write none on these. On something like this board, where we're going to have people who are not public employees, you are more likely to have some sort of business interest or relationship with one of these businesses. And that's a short version of Form 1s. Questions? Seeing none, our next meeting will be Tuesday, April 17th, 2018, 4 o'clock here in the City Chamber. And with that, we are adjourned.
Thank you.